4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning, gentlemen, and we welcome you to the Tennessee Court of Appeals. Appreciate you agreeing to participate via Zoom oral argument. This is not necessarily a way that we would have wanted to do this, but I believe it's the safest way. And for the most part, has been a very efficient way for us to continue to do the business of the court. If we do happen to have any technological glitches along the way, just bear with us. We will we'll get those fixed and get right back with you. Nobody's going to lose any time or any opportunity that you have here because of that. I do want to make you aware that we are live streaming this, and that even though we are not in court, that we are going to follow the same procedure, the same protocol as if we were all standing in court today. Before we get started, though, I'd like to take the opportunity to introduce your panel for this morning. Your panel will consist of Judge Kenny Armstrong from Memphis and Judge Christy Davis from Knoxville. I'm Steve Stafford from Dyersburg. Ms. Tebner, anything we need to take up before you call the case?
No, Your Honor.
All right, you may call the case then.
Stefani Franklin versus Jimmy Franklin.
And we'll hear from the appellant.
Thank you, Your Honor. May it please the court, Lindley Richter from the Memphis Bar. I represent the father, Mr. Franklin. Mr. Jones from the Memphis Bar represents the mother in this case. I've reserved 3 minutes for rebuttal.
Yes, sir.
This is an appeal of a post-divorce relocation case, and so it's somewhat fact-specific. So I'll go through those facts as I believe they're undisputed. The parties, first of all, divorced in February of 2014 after about a 4.5-year marriage. There was one child born of the marriage. That is the child at issue in this case. That child was born November the 12th of 2011. The parties lived in Chicago for a brief period of time and then moved back to Memphis in January of 2013 and continued to live there and have lived there since until this petition was filed. Mother has a master's degree in healthcare administration. She's worked in the healthcare field since that time. And at the time of trial, she was employed by the University of Tennessee Foundation, earning about $81,000 per year. At the time of trial, the child was 8 years old, and the mother was the primary residential parent. On November 11th of 2019, mother caused to be sent to father a relocation letter notifying him that she intended to move with the child to Houston, Texas. Father responded to that letter on December the 3rd of 2019, objecting to the relocation. Just after that, on December the 6th, mother filed the petition for relocation with the minor child, and a hearing was set on that petition by Fayette for December 19th, less than 14 days after the filing of that petition. Father was served on December 9th, hired counsel, and had the matter continued to January the 9th of 2020. On January 6th, father filed his response to the petition for relocation, and in that response, he included a defense under Rule 12.026 and an affirmative defense of failure to meet the condition precedent of notice. 3 days later, the trial began. And during the trial, the following facts were elicited from both mother and father and the maternal grandmother. On January 2013, mother had taken a job at Methodist as a transplant manager, where she was earning about $88,000 a year. She worked there for about 4.5 years before being laid off. She testified, and this is an important testimony of hers, that the area of transplant is where her passion lies. She further testified that it is the best of everything she has ever learned and studied and gives her the greatest satisfaction. After losing her job at Methodist, she began a job search in the transplantation field outside of Memphis. That job search intensified in 2019, and in 2019, she found a job in Houston, Texas as a transplant director. She testified over father's objection that they had offered her a $122,000 salary in Texas, along with a $25,000 relocation package and a bonus of 10%. She testified that she had accepted the position in Houston contingent upon her being allowed to relocate with the minor child. Her testimony was that the cost of living in the Houston area was about 7.5 times higher than in Memphis, and that she would be paying anywhere from $1,000 to $1,700 more in rent in Houston than she was paying in Memphis. The minor child in this case is highly intelligent. He has tested on the autism spectrum, mainly for behavioral issues. He has an IQ, or was tested with an IQ of 127 at the age of 5. At the time of trial, he was doing extremely well academically, and his behavioral issues had become more consistent. Father is very involved in the child's life, and both parents testified to that. He attends doctor's appointments with mother, and when mother can't go, he oftentimes takes the child himself. He was a room parent at the child's school. He's coached the child's baseball team, signed him up for and took him to karate classes. His parenting time consists of every other weekend from Friday afternoon until Monday morning when he takes him to school, as well as every Tuesday afternoon after school and every other Thursday when he doesn't have the child for the weekend. Father testified that he sees the child every day except for those weekend days when mother has her parenting time on the weekends. So he's very involved in the child's life. Eats lunch with the child on those days that he doesn't otherwise see the child. So his involvement is extensive in the child's life. There's no dispute in this case that the maternal grandmother plays a significant or important role in the life of the child. At the time of trial, she was living in Chicago, but she made frequent trips to Memphis. She offered to move to Texas if mother were allowed to move, even though she's never been to Texas. Those are the facts that were elicited at trial that are significant for this case. The relocation laws we have now was signed on May the 3rd of 2018. The new law now focuses solely on the best interest of the minor child. And when you consider that law in conjunction with the legislative or the recent legislative mandate that the courts are required to fashion a custody arrangement that gives both parents the maximum time possible in the life of the child, it becomes even more difficult for the courts of this state to sustain a petition for relocation. Under the new law, the mother's reason for relocation are no longer significant, or sufficient rather. She was not happy in her job. She wanted a different job that was in the transplant field. She wasn't being relocated by her job. She had a good job here in Memphis. She was making $81,000 a year, which is over 2 times the median income of parents in Tennessee. So this was not a situation where she was being forced to move to keep her job. It wasn't a situation where her husband was being relocated and she needed to go with him. This was simply a situation where mother wanted a different job than she already had. She had not lost the job in Memphis, and it was a job paying her, again, $81,000 a year. Her testimony was that the cost of living was 7.6% higher in Houston, and that it would cost her between $1,000 and $1,700 to move or for housing in Houston over what she was paying in Memphis. When you reduce her Houston salary by the 7.6% and then further reduce it by the cost, the average cost of what she testified housing would be, then that brings her effective salary in Houston down to $96,500. So she's only essentially realizing about a $15,000 increase in salary to move to Houston. When you balance this against the impact of the move on father's relationship with the minor child, then the move simply cannot serve as a basis for the best interest of the child. In other words, the best interest of the child cannot be served by mother's move. This was simply a move that she wanted for her own self-interest, not taking into consideration the best interest of the child. Father was very involved in the child's life. he will lose that involvement and has lost that involvement by mother's move. If the father had not been as significantly involved in the child's life, then we may have a different situation here. The court seemed to focus on the lack of a relationship between father's other family members in Memphis. My reading of the law would state that the court is required to focus not on the lack of a relationship between other siblings and other family members, but on a relationship that exists. Neither parent had family members that had a relationship with the child in Memphis. Neither parent has family members in Houston that will have a relationship with the child in Houston. The only testimony about a family member that played a significant role in the life of the child was the grandmother, the maternal grandmother. And the testimony there was that the grandmother lived in Chicago and came frequently to Memphis. She has offered to move to Houston, but that is pure speculation. And the court seemed to focus on that move quite extensively in the order granting the relocation petition, to the exclusion of father. You can't take a grandparent and supplant that grandparent for a parent, especially when the parent who's being replaced has a significant relationship with the child. So the court seemed to focus a significant amount of its decision in the fact that the grandmother would be moving to Houston. And again, that's pure speculation. We don't know if the grandmother is going to move to Houston or not. She had never been to Houston. And that is significant, I believe, in this case. The court is required to focus on the impact of the child as well on this move. The testimony was that the child is doing very well in school. The child was no longer having behavioral issues. And there was testimony that any kind of disruption or change has a negative impact on the child. And that testimony came both from mother and from the doctor that testified, Dr. Leeds. Both of them testified that this move would probably have a disruptive effect on the child that would not be beneficial to the child. Despite that evidence, the court still granted this petition to relocate. Now, under prior law, the court might, or the case may have been a case that would have allowed for relocation. But under the current law as it stands, when we look at the best interest of the minor child, there is no way that the best interest of the minor child could be served in this case by allowing this relocation. There's simply nothing in the record other than the increase in salary, which is minor to mother, that would in any way indicate that the child's best interests are going to be positively affected by this move. So it is our position that the court erred in allowing this relocation and sustaining the petition, and we're asking this court to reverse the trial court and remand the case back to the trial court for whatever further proceedings need to take place in that court. Thank you.
Mr. Richter, the Bowling report and the examination by the child's doctor that was referred to by him during his testimony, is that a part of the record?
I do not believe it is, Your Honor.
Okay.
All right, we will hear from the appellee.
Good morning and thank you. I'm Jeffrey Jones of the Memphis Bar. I represent the appellee in this case. In my discussion, I'll refer to the appellant as the father. I'll refer to the appellee as the mother, and I'll refer to the minor child of the party simply as the child, who, as Mr. Richter said, was 8 years old at the time of the hearing, was in the second grade at the time of the trial. The question before the trial court was whether the mother, who was the primary residential parent at the time, should be allowed to relocate to Houston, Texas with the child, and that's what the trial was about. Before I get into the substance of my argument, though, I wanted to touch on several aspects of this that Mr. Richter may well touch on in his rebuttal, but I think they're important because the record is unclear on this. There was no final order entered in this case until March 17, 2021. The hearing was held January, and the order was entered January 21, 2020. Thus, the question may arise, why was there such a delay from the entry of a final order? That is, why was there such a delay of the entry of the parenting plan that ultimately was entered in the case? Why did it take 14 months to get entered? And let me set the stage on this, so to speak, because I think it's important, especially in the manner that Judge Smith entered the order on March 17, 2021. The trial court ruled on January 21, 2020. The trial court allowed the relocation to take place. The trial court ordered the parties to attend mediation to try to hammer out a new permanent parenting plan to accompany the move. The parties did go to mediation. They completed that mediation and signed by agreement a parenting plan, which was presented to the trial court on February 18, 2020. The trial judge refused to enter that order at that time because of several problems with the parenting plan that we proposed. One, the number of days of parenting time of the father wasn't specified. On page 1 of our standard parenting plans, there's a specification of how much time each parent is to exercise. And even though we had agreed on the intervals of the father's parenting time that was to occur upon relocation, we did not put how many days per year each would be exercising. Also, the parenting plan that we proposed to the court lacked a child support worksheet. So the trial court did not sign our permanent parenting plan, even though we had agreed to it and presented it to the court on February 18, 2020. So the question becomes, and it's going to be asked, why did we delay? Why did it get delayed for a year? As the order of March 17, 2021 implicitly indicates, mother did move. She moved on to Houston. As your honors know, it probably wasn't 2 weeks after we were in front of Judge Smith presenting this parenting plan in February 2020 that COVID hit. There became questions overnight as to whether or not the parenting plan we had signed was going to be effective. I think the court can take judicial notice that for the months following February 2020, transportation was stopped, airports shut down, travel between interstate had stopped. And the parenting plan that the father was going to be exercising his parenting time had ambitious intervals of time that were essentially equivalent to the time that he was already receiving in Memphis. So there were questions as to whether or not we were going to be able to adhere to this parenting plan. And these questions went on for months. So from our standpoint, we were never in a hurry to get a final order in, because we always felt that there might be the potential of us coming back before the court having to modify that parenting plan that we reached in February 2020. The net result was neither father nor mother filed anything to modify that parenting plan. That parenting plan essentially has been in effect since she moved to Houston in February of 2020. We requested that when Judge Smith entered the permanent parenting plan on March 17, 2021, we requested that she enter it not pro-tunc, that it date back to the beginning, but she declined, which is an implicit understanding or an implicit holding that on March 17, 2021, the parenting plan as she signed was effective. So that has to do with why the delay. We've been operating under this plan well over a year. Let me touch on one other matter before I get to my main argument. I need to specifically speak to a certain error I have in the mother's brief. And it namely has to do with the standard of review that's used by this court in a review of the trial court's findings of fact. I used some careless language. I need to own up to it. I stated in my brief that this court should use the abuse of discretion standard in reviewing the trial court's decision. That's wrong. That's the wrong standard. It's close, but it's the wrong standard. Properly stated, this court should not interfere with the trial court's decision except on a clear showing of an erroneous exercise of discretion. That's different than what I said on abuse of discretion. Abuse of discretion is how the court evaluates evidentiary rulings at trial. But I wanted to make sure that it's understood. I acknowledge my mistake on that. Clear showing of erroneous exercises of discretion is the standard that should be used by the court. As to the substance of my argument, I'm going to address some of Mr. Richter's points. The trial court made a number of fact findings in the court's written ruling. The trial court took pains and great effort to analyze each of the statutory factors at 36-6108 paren C, the parental relocation statute. The judge made specific findings of fact as to each factor of the statute. The judge analyzed each of the factors in the order in which they appear, although no one factor is necessarily more important than any other factor. But I want to touch on category-wise what the trial judge ruled. I'm going to break it down into the four areas that she looked at the facts. First area, and I'm going to come back and discuss this later, but the first area was she felt the move, if she allowed the relocation, the trial judge allowed it, the move would enhance the quality of the life of the mother and the child and would give them a greater and increased financial benefit to the child. Second point that she made and elaborated on is she felt the child would receive immediate positive education benefits from the move. Third point that she elaborated on was she felt a complete absence of quality involvement of the father with his family, whereas the mother had significant involvement with her family was an important factor to be considered. And the fourth matter that Judge Smith dwelled on was since the mother was the primary residential parent, she felt that the mother was making more responsible medical decisions and dealing with the child's behavioral issues by putting the child in various programs. And she made specific findings of that. As to the first, the enhancement of the quality of life, which is subsection F of 36-6108 C. The court made findings that this move, the relocation, if allowed, would give a clear professional benefit to the mother. It would greatly increase her income, roughly 75% over what she was making at the time. It needs to be kept in mind that when she moved here, along with the husband, when they were married, moved here from Chicago in 2013, the move specifically was for the reason for the mother to take a transplant coordinator job with Methodist at the time. That's why they moved from Chicago to Memphis. Unfortunately, after she was here for 4 years, they phased out, and it's through no fault of her own. She lost that transplant coordinator's job. And so as a result, she began looking for other transplant jobs in other cities of the country. There's testimony in the record that she looked in at least 4 other cities and looked at transplant opportunities in those jobs, in those cities, even interviewed with several of them. But with each of those opportunities, she concluded the move was not in the best interest of the child because the move would be too far away. It would keep the father from exercising his time. Airports weren't close by. She ultimately, though, received this offer from Houston, in the Houston Medical Complex, and that was the job that she then presented to the court. It was going to be a transplant manager's job, just as she had had before, and it was going to be a great career advancement for her. This is the first factor the court felt was a strong factor in her move. The second factor the court dwelled on was the educational opportunities in Houston were going to be superior to what the child was experiencing in Memphis. Testimony was from both parties that the school that the child was going to at the time was not giving the child the best of educational opportunities. In fact, the father greatly disparaged that school that the child was attending. He even threatened the mom to move the child to another school, which she never did. But the result was he continued to express his disapproval of the school the child was attending up until a week to 2 weeks before the mother proposed the relocation. And at that point, he then switched and said, no, hey, he believes that the school is actually adequate, but that was inconsistent with his testimony and his statements up until that point. So we believe that the presentation of the change in education to the Houston, Texas schools was going to be a positive in the child's life. And that's one of the aspects Judge Smith dwelled on. Judge Smith did touch on, as Mr. Richter said, these significant relationships that the parties had with their relatives. The testimony from the father was he hadn't seen his parents in years, didn't know where they were. He had a 16-year-old daughter he had essentially nothing to do with. He had a 20-year-old daughter he essentially had nothing to do with. Whereas mother had extensive relationships and the child had extensive relationships with maternal grandmother. Maternal grandmother was frequently came down from Chicago. The testimony was monthly, spends time with the child. And the maternal grandmother was going to move to Houston to assist in the child rearing and upbringing of the child in Houston. So the court was definitely impressed with the significant relationships of the mother with her family and the lack of sufficient relationships with the father. And that's subsection A. That's one of the factors that the statute calls for.
Let me ask you, Mr. Jones, before the trial, were you aware that Dr. Leeds was going to testify and that he was going to say, based on his review of the Bowling report and the examination by the child's doctor, that this move would have an adverse impact on the child because the child doesn't like change or transition?
I'm glad you asked that question. The record will show that I found out about the testimony of Dr. Lee probably 24, 36 hours before he testified. As I said earlier, we had to put this case together very fast. The mother had a job offer. It had to be accepted or rejected within a short period of time. I could have asked for a continuance when Dr. Lee was sprung on me at the last minute. That would have defeated the whole purpose of her asking the court to consider the relocation. So we went forward on the proof. I disagree with that characterization of Dr. Leeds' testimony. I think his testimony, when looked at on all fours, was that he only looked at some of the medical records. He didn't look at all the records. He talked to the father. He didn't talk to the child. He didn't talk to the mother. He did very little in the way of investigating to come up with a personal opinion, that is a personal professional opinion, as to what would be in the best interest of the child. So as a result, and that's what Judge Smith found at the trial level, she discounted his testimony on the basis of lacking a foundation to give his opinions. His testimony was indeed that there can be adverse consequences to a child that goes through a relocation. But my reading of the record was he never said that there would be adverse consequences to this specific child based on his examination.
Who prepared the Bowling report, Mr. Jones?
I assume the Bowling Center did. They are a branch of the University of Tennessee. But
And is that report not consistent with Dr. Leeds' testimony?
that one report is. Dr. Zebart had different information that Dr. Lee acknowledged that he didn't. Dr. Zebart was the doctor who had prescribed medication, was the longtime pediatrician of the child. And we think that doctor's testimony should have been weighed and considered by Dr. Lee along with everything else he did.
All right, thank you, sir. You have used your time. We'll hear the rebuttal from the appellant. I think you're muted, Mr. Richter.
Thank you,
There
Your
we go.
Honor. First of all, I'd like to take issue with the standard of review. I believe the standard of review is de novo with the presumption of correctness unless the evidence preponderates otherwise. And I believe that's the correct standard for the evidentiary rulings of the court. As for the statutory interpretation, it would be de novo with no presumption. Going back to Dr. Lee quickly, and I'm going to go backwards with what was said. Dr. Lee did look at the records of the child and did make an opinion or offer an opinion that was directed toward this child and the move of this child, and opine that this would not be in the child's best interest. One interesting point that we've all looked at is in the best interest analysis under under the relocation statute, C subpart 2 subpart A, the nature, quality, extent of involvement and duration of the child's relationship with the parent proposing to relocate and with non-relocating parents, siblings, and other significant persons in the child's life. That statute focuses not on a lack of a relationship between relatives, but on a relationship. If there's no relationship, that should not be used against the parent or against the child. So the focus should be on what relationships do exist between the child. And I think a lot of emphasis was placed on the fact that father, for whatever reason, did not choose to include certain family members in the child's life. And there's nothing in the record to indicate why. But it's irrelevant because you have to focus on what the child's relationships are, not what they're not. Interestingly enough, the Mr. Jones focused on exactly what the court focused on, and that was the financial enhancement to mother, the mother's desire to relocate, her ability to get a job and feel good about that job. That's not focusing on what's in the best interest of the child, but on what mother wants. And the biggest problem that I think we have in this case is that everything tends to focus on the position that mother will have, the money that mother will make, the enhancement to mother and not to the child. And again, when you take into consideration the increase in cost of living in Houston, it's really not that big of an increase in income that mother's going to experience by being in Houston. How can we say that that is somehow going to enhance the well-being of the child? Additionally, there was no testimony in the record as to what school the child would be attending or to what enhancement his education would have in Houston.
All right, thank you, gentlemen. I appreciate your argument. We will take this matter under advisement and attempt to get you an opinion resolving this issue at the earliest possible time. Again, I want to thank Mr. Hibner and his staff for being the quarterback of all this and making it work, as well as the AOC staff. Mr. Hibner, anything we need to take up before we recess to the call of the next case?
Oh, Your Honor.
Okay, if you'll recess court then.
This honorable court is now in recess until 11 a.m.
Thank you, gentlemen.
Thank you.